Excellent. All right. I'm assuming by this point you know how to navigate the Zoom world. Do you have any questions for me? Is there
Yeah, I just see, I don't have a list of all the co-sponsoring ACS groups. So if you could just tell me, because actually my email is down now, but otherwise I'll just say, the at-large chapter and many other chapters bring you this session.
Give me 1 second and I can see if we've got that. It should be on the event page. Just one moment here. I will drop this into the chat for you. I'm gonna clean this up. It didn't transfer the nicest.
Oh, I found it. I pulled it up. So I'm just going to write down the names of the different chapters.
Oh, I've got this here for you. I was just cleaning up the formatting, didn't copy over to the. There we go. Oh, you don't have to write that down. And then, so you both should be hosts. I'm going to stick around until your intro is kind of off and running, and then I'll go ahead and drop off. But I'm going to go ahead and turn off my camera now, unless either of you has questions or there's anything else I can do to get things ready to go in a couple minutes here.
Great.
Okay.
No questions. Thank you.
Thank you both so much for agreeing to this event. Super excited. We had a good registration list last time I checked. So
great.
It looks that way. So I guess we'll just wait another minute or two and then we'll click start.
Sounds perfect to me.
Right. Have you given a lot of lectures? I guess you're a professor, so you're used to this.
Yeah, so the lecture itself, obviously, that it's happening, 3 days a week for classes. And then, but for the book itself, yeah, since it came out in September, I've done a lot of talking around it and a few in-person events, happily, but most of them have been on Zoom because of the pandemic.
Yeah. I'll tell you, I miss in-person meetings. They can be much more interesting, although Zoom is much more convenient, to say the least.
Yeah, it is very convenient. I've been able to reach audiences for sure that I would have a tougher time scheduling, with everything else going on. So there's the pluses and minuses for sure.
No, I'm a Rotarian, so we had a meeting that came out of Germany this afternoon, and there were like 140 people from around the world on it. It was very interesting. It would never happen in the real world.
Right. And you're obviously going into your office, it seems.
I've been going in since around June of 2020. So when I was one of the first ones in, we have all sorts of safety protocols. So I never got COVID.
Nor have I. We're the fortunate ones.
Yeah. Right. I think I'll click on, it's 6 o'clock. I'll click on start webinar and let's see what happens.
Perfect. Thanks, Shannon.
Okay, Wilfred. Here we go. Okay, I see that people are logging in, so we'll wait. I think we're waiting for about 80, 85 people. So
Sounds good. Maybe to give some time for the ambulance to go by. That's in my background.
here in my building, they're doing construction on some of the other floors. So sometimes in the middle of a meeting or whatever, you know, we just hear, sounds like jackhammers, whatever, but it's pretty quiet now. Everybody's gone home. Well, we're up to 27 and it's gone slowly. So we'll just wait another couple of minutes and we'll see. Okay. Okay, well, we're going to start then. So welcome to everybody who's on this Zoom call. I'm sure we're going to have a very interesting evening. This is a program sponsored by the at-large chapter of the American Constitution Society, of which I'm vice president. I'm Jan Brown. We also thank the Delaware, Dallas-Fort Worth, Michigan, Bay Area, San Diego, and Washington, D.C. lawyer chapters for co-sponsoring it with us. Welcome, everybody. So now I have the pleasure to welcome our speaker, Professor Wilfred Codrington, who the third, got that done, who is a constitutional law scholar at Brooklyn Law School. His teaching and scholarship focuses on constitutional theory and reform, election law, voting rights. He's a non-resident fellow at the Brennan Center for Justice at the NYU School of Law, where he was previously the Bernard and Spitzer Fellow and Counsel, focusing on voting and election security, constitutional reform, and the rule of law. He's taught extensively at the NYU Wagner School of Public Service on law, public policy, politics, and more importantly, and germane to what we're hearing tonight, he's the co-author of The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union from the New Press. It was published last year, which examines the history of US constitutional change, specifically through the Article 5 amendment process and the need for a renewed American conversation about our Constitution. As he's written extensively in the fields of constitutional law and election law, in academic journals and popular media, I'm sure that we're going to have a very in-depth and profound discussion, and we'll all walk away with a much deeper understanding of the topic. So Professor Codrington III, welcome.
Thank you. Thank you. Yeah, first I want to say thank you to the American Constitution Society in general and the lawyers chapter, the at-large chapter here, and the other ones who are helping to sponsor this event. Thank you. And thank you, April Day, for helping behind the scenes, coordinating all of this. I think so much goes on behind the scene, and it usually goes unnoticed and unappreciated, but I do notice it. Jan notices it, so we appreciate that. And of course, you, Jan, thank you for moderating this evening's talk and really for your work with ACS and your work generally that's aimed at making our city and our state and our nation just much more fair and just. And as Jan said, my name is Wilfred Codrington. I am an assistant professor of law, and I am a non-resident fellow at the Brennan Center for Justice. And so I'm here to talk about the book. The book is called The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. And the broader question that it seeks to answer are two. First, how should Americans understand the story of the US Constitution and constitutional development over time? And second, what might that continued development look like in the future? So at the core, the People's Constitution is a narrative history of American constitutional reform and constitutional development. Unlike many of the books covering this topic, the main focus here is constitutional amendments. So after briefly recounting how we got the original Constitution in 1787 and what that Constitution was and what it looked like, including its original flaws, the book begins to chronicle some of what I believe are some pretty fascinating stories. And those stories are from the 1790s through modern times, and they explain how and why, in light of experience, under the Constitution, the American people periodically amended it. And so that is to say, how we came to acknowledge our governing charter's shortcomings, its omissions, its flaws, and then why we altered it in the way that we did. And what we did was to produce a charter that we know today, a charter that is far, far to a greater extent than it was in the 1780s and 1790s, protective of democracy, the promises of equality, and the guarantees of individual rights. It is, in brief, by adopting these 27 amendments, we have made this Constitution and the nation much more democratic, more inclusive, and more suited to governing and evolving American people. And so that's what this book seeks to do. It seeks to capture how the Constitution, with its amendments, the amendments which rival the original document in length and importance, have moved the country and the Constitution towards that more perfect union that we wrote about in the preamble. And so the big takeaway here is that the American Constitution and constitutionalism is progressive. And so me and my co-author, we narrate this to push back at what is the conservative account of American constitutionalism, this conservative account, which has become quite pervasive. And that account has dominated the national conversation about the Constitution with a story that pretty much begins and ends in the 18th century. It is your James Madison, your George Washington, and maybe with a sprinkling of Abraham Lincoln for good measure. That narrative also repackages the anti-federalists as if they were the victors in history. And our book explains why there is so much more. And so the goal is to present a clearer and more complete picture through a book that is both rigorous and authoritative, but accessible. And we do this by weaving these voices of historical figures to describe these pivotal periods and these key events that resulted in constitutional amendment. And so by using letters and congressional floor speeches and addresses and newspaper clippings and things like that, we try to make the reader feel like what it felt like during those times to capture what was occurring. And so the Constitution is undoubtedly progressive. That's its development. Another major theme is that the American people have the tendency to amend the Constitution, not in a staccato manner, but in waves or in thematically consistent clusters. And this is underlying the bulk of the book. So in 4 major chapters and then 2 shorter ones, we describe those periods and the change that stem from them. So we tell the story of the founding era amendments. That's principally the Bill of Rights, which were adopted to give vital protections for civil and political liberties, and the rights and substantive criminal law and criminal procedure protections. And this was really a story of damage control. To mend some of the most flagrant flaws and to shore up support for the Constitution by appeasing its detractors. During that period, you also get the 11th Amendment and the first failure and the first patch of the Electoral College, and that's the 12th Amendment. So taking together, these amendments largely acted as a limit on the federal government. After that, we chronicle the fight for the Reconstruction Amendments. And as you know, these 3 amendments gave us abolition, equal citizenship, and the right to vote for Black men, they were the capstone of the abolitionist movement and the push for Black dignity and equality. The story of Reconstruction and its amendments, these amendments that expanded the scope of federal power and restricted states, this is a story of the country's moral decline to its promising rise to its squandered victory. And this is because some of the grandest pronouncements ever added to the Constitution were ultimately twisted and truncated and ignored during the 8 or 9 years of the American apartheid or Jim Crow. Meanwhile, the crown jewel of this era, the 14th Amendment, starts to be abused by corporate titans, which leads us into the progressive era. And during this period, we see insatiable greed, corporate greed, rampant government corruption. This is the Gilded Age. But we also see these movements, and we can see what these movements really achieve. The constitutional amendments during this period, they bring the Constitution into modernity. We get the income tax, which makes our country more equal and puts us on the stage to actually act as a world power. We get the direct election of senators and women's suffrage. We also get the ill-fated 18th Amendment, the Prohibition Amendment, which itself has been a lesson in many things, including because it is the only amendment to have been repealed. And then finally, we have this most recent period of amendment, and that came during the Civil Rights era. Now, notably in this period, you have Cold War fears, and they ultimately converge with President Kennedy's death, which leads us to the 25th Amendment, clarifying presidential succession. Sandwiching that 25th Amendment, though, you get 3 other amendments, all of which are focused on expanding democracy again. And they open up the Electoral College to the residents of the District of Columbia. They outlaw the poll tax, and they lower the voting age to 18. And to be sure, these amendments were fairly small ball amendments, especially if you compare them to the amendments that we got in the prior periods, because the real energy in this era was really going to other things, your Civil Rights Act, your Voting Rights Act. And then when progressives finally get to the point of pushing for 2 more ambitious amendments, the Equal Rights Amendment and a more complete District of Columbia amendment, they end up falling short in the states because that amendment energy has been sapped. And so these 4 thematic periods are told in these colorful, digestive vignettes. The flip side of this is that we have this, what we call a cluster theory. And that is this sort of like dichotomy between quiescence and the flurries of activity. So the cluster theory is these bunches where we get these amendments in the 4 periods. But amendments are happening in these short bursts. For the most part, though, what we're doing is not amending. It's these periods of quiet. No formal amendment is happening. And instead, we have these decade-long periods that are just relative lull. So we have 61 years between the 12th and 13th Amendment. We have 4 decades between the 15th and the 16th Amendment, 4 more decades between the 19th and the 23rd Amendments, and then 50 years between the 26th Amendment and today. And during these dry spells, Americans are doing a number of things. One, we're trying to adjust to the recent periods of change. We're engaging in contestation. So we're trying to figure out what the new amendments mean and how they'll be implemented. And then we're also figuring out the Constitution's other shortcomings in light of this new experience. And these shortcomings are what's going to drive the next wave of amendments. And so we try to tell those in these sort of brief intros and codas to the next chapters, and they give you context for the next wave that you're going to read about. And I'll say one more thing that is pretty important about the book is we, in the end, talk about these catalysts and these indicators, which are basically a combination of these things we see, these concepts that are present in the lead up and during major amending periods. And when we do this, what we are saying is it's high time for the next wave of constitutional amendments because we're seeing them today. So history has a way of telling us that we are ready for more amendments with these patterns. We see them in unpopular Supreme Court decisions. We see them with political foment and experimentation in the states. We see transformational social change, which often have implications for demographics and technological innovation. We see intense political polarization, and we see a sense of insecurity, which is often in the lead up to the war or economic crises and their aftermath. And so these are the catalysts that we have started to see today, which lead my co-author and I to be cautiously optimistic that we are ready for the next period of change. So one thing you'll note is that the People's Constitution is an outlier of books for this current era, because what we have been talking about is very different from what's been selling. The things that are resonating right now are about the death of democracy and on tyranny and the things like that. And again, we're trying to be cautiously optimistic, but taking a view of the possible. It is very odd because when we started this project, it was at the time when the Electoral College misfire gave us Donald Trump for president. Donald Trump was really, really bad at his job in all of the forms and unprepared to lead the nation. And so we had that. And we're still dealing with this pandemic, so we're still in somewhat of a low. But in a way, these sorts of things, again, highlight the need for constitutional change. It highlights the need for why we need to amend the Constitution. And so what we're trying to do is to use this book as a sort of launching pad for a bigger civic conversation about how amendments have happened in the past, how they can happen, and what the Constitution might look like, again, if we amend. And yes, it is difficult to amend the Constitution. It takes 3/4 of the states to ratify it after you get 2/3 of each chamber of Congress to adopt them. So it can seem like a Herculean task. It can seem like a Sisyphean task, right? But prior generations of Americans have always had this complaint and other reservations that we hear for why we don't amend the Constitution. And yet the things that you hear now, we've heard then, we think that they are not insurmountable. They are not insurmountable. They're not noise, but they're not insurmountable. What we're seeing right now is that there's a potential here. We're seeing increasingly sophisticated social movements. We're seeing catastrophic events. We're seeing really, really bad political and legal decision-making at the Supreme Court. And these are some of the factors that have made what seemed impossible in the past actually possible, which led to some clusters of what have really been some common sense changes to the Constitution and have improved things tremendously. And so we think, or at least we hope, that this will end up being a value add over time. With that said, I will happily take questions from the audience. I don't want to sort of talk myself to death. I think that this can hopefully start a really great conversation.
I would suggest that people send into chat your questions, and we will deal with them that way. In the meantime, since it looks like we have one already, let me look at it from here. Can you see it, Professor, or should I read it?
It would be great if you could read it.
Okay. First, a compliment. Excellent presentation.
Oh, thank you.
Just got to start with that. You briefly referenced how business corporations have used the 14th Amendment. Could you please comment on the hijacking of other amendments, such as the 1st, 4th, and 5th, and the need to pass a constitutional amendment to end all intended corporate constitutional rights?
Sure. So, so what I was referencing was the 14th Amendment, this Equal Protection Clause, this sort of due process, liberty, these important concepts. What happened after the Reconstruction period is that was just largely ignored. The intended beneficiaries were obviously African Americans who were once in slavery. And the idea was that this was supposed to renew that sort of promise that was in the Declaration of Independence and the founding documents. And so what we saw was nearly a century of Jim Crow and that amendment and others being ignored. And instead, that was being used by corporations. And so there was this sort of concept of corporate personhood that these corporations were supposed to have constitutional rights or legal rights that, they were using the 14th Amendment as the vehicle to assert this. And so you saw this with the sort of tycoons of the railroad industry really starting things up, where they were basically arguing that the 14th Amendment was there to protect them. And there was a pretty pernicious sort of scheme to kind of get that underway, of which Professor Adam Winkler, who I believe is on the ACS National Board, captures pretty well in his discussion about the progressive era. And so, yeah, so 14th Amendment completely abused and ignored for African Americans and abused by corporate titans. And we saw what happened then. We were in this Gilded Age where there was this chasm between the have and the have-nots, and sort of just killing like the ideas of progressive wage laws and things like that. And so I guess the question today is how other things have been abused. The mention was the First Amendment. I think that was the first one mentioned. I think what is notable about the First Amendment is the fiction of the First Amendment equating money with political speech. That is sort of Buckley and Citizens United and the line of cases in that regard. And what we're seeing is unprecedented amounts of money that are influencing our elections, our political process, really crowding out everyday people from getting their voices heard in our democracy. So it's really undercutting the idea of a representative democracy because we're not being represented. And instead, we have sort of our representatives being captured. And this is not this is not unique to one party or another. It's happening all the time if you look at the reports of the money that is flooding in our political system. So I think that's really problematic. And so one idea here is that sort of, again, one of the things that I spoke about that sort of opens the windows for constitutional amendments is really bad decisions by the Supreme Court. This actually has been the greatest catalyst for constitutional amendments. In every period, there has been at least one major Supreme Court decision that had to be overturned through a constitutional amendment. And I think this discussion about the sort of corporate takeover of the 14th Amendment, and particularly in our political system, suggests the need of doing something about Citizens United and sort of reversing the effect there.
Okay, we've got a couple of observations from participants talking about the extreme partisanship that exists both in the states and in the Congress. So the question is, how could anything so significant as a constitutional amendment proposal get through Congress and then get through 3/4 of the states with the current climate that exists in our country?
Yeah, so and again, I can't say that past is prologue, but what I can do is draw on history to show that this has happened before. It happened before in certainly in the Reconstruction era, right? You had probably the most divisive Congress that you've ever had, to the extent that it brought us to civil war. And so you had a complete breakdown in our governing and a secession. And so that sort of polarization was so intense that it required constitutional amendments to alleviate the problems of slavery and the like. I think the better comparison is what happened during the progressive era, right? And in this period, what you had was you saw the sort of polarization that we see now. You saw really, really close elections in Congress. You saw electoral college misfires. You had 2 of them within a period of 16 years. So that sounds pretty familiar. And you had, ultimately what happened was you had this sort of reconfiguration of political parties. And that's because there wasn't one thing just driving the parties. There wasn't this unity. And certainly at a certain point, like things had to factionalize. And what you had was the political parties actually, like, being pushed by populists, by progressives to actually do something. And it wasn't just unique to one party. And so there was a reconfiguration there. There was also a reconfiguration during the civil rights era, right? So like, we don't think about it now, but that was like a lot of that was the movement of the Republican Party in DC that was doing the work of progressive civil rights. But they were also working with the FDR coalition. And obviously a part of the FDR coalition was sort of trying to stop progress on racial issues, particularly Southern segregationists, right? So, but it wasn't like one party versus the other, even though you still had this polarization. And what that meant was there had to be some coalition building to actually effectuate big change. So that brings us to today. We see like complete polarization to the point where members of political parties are being censured or maybe kicked out, who knows, for speaking the truth about things that are so obvious and patent to all of us. So, if we look at these political parties and we look at the sort of factions within them, it's not clear to me that that is permanent and stable. And so I don't know what the sort of depolarization looks like, but what I know is that this polarization that we see now, I don't think can stand. And to the extent that it is in the interest of certain political parties and political actors to like continue this, right, to stop any progress and to continue to manipulate the machinery of democracy so they can thwart any sort of progress, like that's going to happen. But I think that there becomes a tipping point where that has to give. That again, past is not prologue, but I think we saw examples of that in the past periods.
Okay, well, do you have any specific amendments that you'd like to see adopted today? That's a question that's asked of you.
Yeah, so this is, I have a number of them, so it really depends on how much time you have. But I'll just name a couple. One I'll put in the bucket of democracy, right? Expanding democracy. And we see that that also is a big category for constitutional amendments because one of the functions of the Constitution is to regulate our democracy. And over time, it's been progressively opened. And so I think it's high time to, one, eliminate the Electoral College. That has been one of the two most popular subjects of constitutional amendment in history, with 800 to 1,000 different resolutions introduced in Congress to get rid of it. And we got quite close to that actually in 1969, 1970. But again, what you had was Southern segregationists using the filibuster to thwart that. So it got past the House of Representatives. It had the support of 80% of Americans. And then you had Strom Thurmond and his segregationist cohort stop it with the filibuster. So the Electoral College, I think, would be one of them. I am one of the people who think we need an affirmative positive right to vote. We don't have one. 49 state constitutions do. But I think that when we look at what's going on in the states, at the state Supreme Courts, how they interpret their sort of free and fair election clauses and their right to vote, it is more robust. And so I think it may be time for that too, as opposed to the anti-discrimination framework that we have in the 15th, 19th, and 24th and 26th Amendments that just basically prevent people from interfering with voting as opposed to explicitly providing a right to vote and setting that out. And that could be very robust, to include things like anti-gerrymandering and maybe getting rid of prison disenfranchisement, for example, in addition to just like a general protection for the right to vote. I mentioned Citizens United and sort of getting rid of the damage that's done. Something that's up right now is the Equal Rights Amendment. So we'll see what happens with this. This is very hotly contested right now, but I think it is, again, high time for this notion that gender equality is a constitutional norm that should be taken for granted and enshrined in our, should not be taken for granted and should be enshrined in our Constitution in a serious way to set an example and to actually pave a path for other things. We might think about Supreme Court reform. There's just like a number of them right here that I can rattle off if you give me the time, but I will let that sort of fester and we'll get to the next questions.
Okay, so now we have a question. Oh, I have a follow-up on the Equal Rights Amendment. As you know, it's been pending for decades, and some states are considering revoking their approval of the amendment. So, what are your feelings or estimates of how successful it might be for a state to revoke their approval of a pending amendment?
Yeah, so I think that's a really deep question, which can be answered sort of simply, but not really. So right now, what we had with the Equal Rights Amendment, there got to a point in the 1970s where 35 states had ratified it, 35 states. So you were 3 states away from it becoming a part of the Constitution then. There was a conservative backlash. Many people know Phyllis Schlafly leading the anti-ERA movement, but the rise of the conservative right and sort of like what brings us to today, the dominance of conservative legal thought. And so that was all happening at the same time. There was an extension of the deadline to ratify it. It became pretty commonplace to include a deadline for ratification for constitutional amendments since the early 1900s. And they did that with the ERA. So it was extended. That became controversial. That was contested. It went to a district court in Idaho, actually, that challenged it. But ultimately, the new deadline, the advocates of the ERA did not meet their 3 more state ratifications by the new deadline. So that case by the district court became moot. The Supreme Court just sort of got rid of it. And then in the interim, there were also 5 states that purported to rescind their previous ratification. And so what's happened today is in light of a lot of what's been going on, the women's movement, sort of Me Too, and that sort of energy, I also sort of backlash to our previous misogynistic president who I'm sure riled up some of the energy. I think it gave some motivation and energy to the push for the ERA to continue the work that it left off. And so there's been this idea of a 3-state strategy, which was to pick up where it left off and get those 3 last ratifications to make it actually a part of the Constitution. That doesn't deal with the 5 states that purported to rescind theirs or states that might try to do that now. Ultimately, what I think is going on, or what is happening, and so ultimately it comes to the archivist of the United States to proclaim that an amendment is ratified, and this archivist, our current one, who is about to retire actually, has said that he is holding off. He's taken the advice of the Department of Justice that he can't do anything about this, but he also says that he wishes he could. So there's sort of unclarity there. My perspective on this is that these are very complicated questions, but what is not complicated to me is if you look at the language of Article 5, it mentions no place for anybody but Congress, right? Congress is intended to be the gatekeeper of constitutional amendments. Congress proposes amendments unless it is coming through some sort of convention that is called by Congress. So Congress still has to call this convention if enough states actually call and push for it. Congress decides how we ratify. So it gets to determine whether ratification is through state legislators or popularly elected conventions in the states. And it's Congress that is like kind of controlling this process. Nobody else is sort of mentioned in this process, not the Supreme Court, not the executive branch, not even the archivist. And in fact, the archivist is a ceremonial role to do something that, that Congress passes a bill to certify and proclaim something amendment. So as far as I'm concerned, I think Congress is really in the driver's seat, and the Supreme Court has indicated as much in some earlier cases that came before it, questioning the legitimacy of some previously enacted amendments. And, we'll never know what the Supreme Court will do. I think we're concerned about the Supreme Court sort of overturning a number of things. So that's always an open question. But I think it's up to Congress to make determinations about these difficult questions, because it is really a political question for that branch to determine what is and what is not a part of the Constitution, in the same way that it was for the 27th Amendment, right? At some point, the archivist said that the 27th Amendment, which was ratified 200 years after it was actually proposed by James Madison, so it was ratified in the 1990s. The archivist said that it was duly certified and a part of the Constitution, and Congress, they kind of had misgivings about this, but ultimately what they did is they passed resolutions saying, yeah, this is a part of the Constitution. Now, there might have been political pressure for them to do that, but ultimately, I think that shows that Congress is in control. Congress should be able to lift any deadline if it wants to do that. Congress should make determinations about whether rescissions or these purported rescission aids are valid, and Congress should make the decision of whether this current Equal Rights Amendment is valid or what we should do going forward.
You touched upon a constitutional convention, which is also percolating through the country. So do you have anything you want to comment about that?
Yeah, so the constitutional convention approach, that's the alternate approach to proposing amendments. And that's if you get 2/3 of the state legislators sending these petitions to Congress, then Congress has to call for a convention where they'll propose amendments. Now, this has never been used, and it's pretty clear to me why it has not been used. If you look at Article 5, and I've been sort of spouting off a bit about Article 5, which is the amending provision of the Constitution and tells us how we amend, it doesn't provide much. It's pretty scant in terms of the terms of it. And it certainly doesn't provide rules or regulations or processes or how they think about constitutional amendments. And frankly, when the idea came in, and the idea came in at the push of the anti-federalists. So this is James Madison trying to appease the anti-federalists who wanted to destroy the Constitution. It was really trying to, one, change the structure of the Constitution so states had more power, but two, just an attempt to sort of a delay tactic about trying to get another convention at that point in time to get a new constitution. And so it was sort of misguided in the way that it got into the Constitution in the first instance. But every time we've come close to having a convention, and we have in various parts of history, conservatives have pushed for a convention to get rid of the one person, one vote doctrine. Conservatives are now pushing for this balanced budget amendment, which sort of failed, and they're trying to revive that. Conservatives are pushing for even more things like this sort of convention or to propose amendments to curtail federal power. And really, and then we also had one convention that actually pushed for the 17th Amendment, so the direct election of senators, and that actually egged lawmakers to actually propose it. So they did not go to the convention route. But there are no rules about this. And frankly, the first convention and the only convention we can really look to for what is possible there is the convention that gave us the Constitution. And we got a Constitution through that. And it was better than the Articles of Confederation that existed. But the goal, the purported goal or the stated goal and the legal goal on their commissions of the delegates was to give us revisions to the Articles of Confederation. And what they did was they scrapped it, and they didn't care about the rules of the Articles of Confederation. And so the modern day equivalent of that is this push for a convention would go off the rails with this runaway convention where you don't know what's going to be on the agenda. It doesn't matter what was in these petitions to actually get a convention, and people will try to change the rules. There's also just a concern about who would be attending these. Would you have lobbyists flocking on these conventions trying to get their interests enshrined in the Constitution for eternity, right? These are really, really tough questions. And every time we've had a push for amendments, cooler heads have prevailed, and the push sort of went into at least we'll say quiescence, right? Because there's a new one that's trying to build on the last one. So I think that is a terrible idea. I think that, there's a lot of open questions about it, and I don't trust the people who would actually be deciding the decisions about those old open questions.
Okay. Do you see the National Popular Vote Interstate Compact as a viable means to bypass the potential difficulty of getting congressional and state approval of a constitutional amendment to remove the Electoral College?
Yeah, so the National Popular Vote Compact is, and just to explain it quickly, it builds on the idea and the Electoral College system, right? So we have the Electoral College system, and the Electoral College says that state legislators get to determine how they allocate their electoral votes. And currently what we do in all of our states, at least in some fashion, is that we give it to the people vote for that, and that vote is going to be binding, and it will determine that state's particular share of electors. What the National Popular Vote seeks to do is to say, well, state legislators would enter into an agreement with other states that it will come into effect when you get enough states to determine the presidency. And instead of awarding the electoral vote to the winner of the popular vote, the presidential candidate winning the popular vote in a particular state, you're going to award it to who wins the most electoral vote, I mean, the most votes nationwide. So if you win the popular vote nationwide and you have 270 electors worth of states in this compact, that's going to be able to determine and ensure that the Electoral College is also going to the person who wins the popular vote. So it is in this way to use the Electoral College to get to what is in effect a popular vote for the presidency. And I do think that is viable. I've written about this both in sort of popular media, but also in an academic journal. And I think that it is a great idea. Right now, there's political difficulties. Right now, the states, they're about 75% or so of the way there, so pretty far along the way. But we've gotten to the point where it's mostly blue states that have signed on and one purple state, Colorado. So it raises the question of what's the way forward there. And certainly, I think we could talk strategy about that, and I think some advocates are. But I think once you get there, it can be this sort of technique that it does a couple things. One is that it shows that a popular vote is not all that bad, right? It's actually pretty good. The popular vote is the way that we choose all other officials in every other context, and the Electoral College is this outlier, has prone to failure, right? And it's popular vote aligned with the Electoral College for most of our presidential elections. So why would we want to debase the vote of anybody else through the Electoral College and not treat people equally? So it might do that, and then sort of open this door and our hearts in America to the idea of actually amending the Constitution to get rid of this Electoral College once for all. So it lays the ground for this popular vote and gets us to be pretty confident and comfortable with the popular vote to get rid of the Electoral College once and for all. But there's going to be challenges to it. There's going to be legal challenges. And again, like with the convention method, were we to get to there, I don't believe, I don't trust the people who would be making the decisions ultimately if it ends up being the court. But I think the Electoral College is an innovative way to use the current system and to draw on our federalist system, building on the state action to try to get the popular vote that we have for every other election and we deserve.
It would be interesting if this compact passed, and then after the census, some of the signatory states lost some of their electoral votes, and then they need to find another state. Just a thought.
Yeah, no, and then this is why the compact can't be a permanent solution because of things like that. When you get reapportionment, you might get a state that loses two seats, right? And then you're under the 270 that you need, and what happens? Well, the actual legislation that state legislators pass to enter these agreements takes into account, what happens in these cases. It just means that the effect kind of goes into abeyance again. And for example, it would bind these states to remaining in the compact up to 6 months before a presidential election. So you can't 6 months there, you can't leave it, but like that's going to be contentious. But if somebody does end up leaving, then again, the agreement goes into abeyance. So it is not a permanent solution. But again, I think about it as something that can lay the ground for us to become comfortable again with a permanent solution, which would come through the abolition of the Electoral College, like we were starting in the 1970s anyway.
We have a question here to you, Professor. Did you consider that a legal succession amendment might be supported by both the Federalists and Anti-Federalists, and thus might be able to be passed and then allow the reduced USA and the set of other states to have supermajorities to pass other amendments in their part of the country?
So a legal secession, is it secession we said, or succession?
Secession.
So I have not, I mean, like I sort of thought about it in the abstract, secession, because like the state of the world today, right? We saw a coup and a president that encouraged a coup. And you think about that sort of violence, you didn't see that in the Capitol, except for not even during the time when we actually had a purported secession in the 1800s, right? So I thought about it, like what happens if you get to a point where the Constitution is so broken that it's not working for people? Well, then people start thinking of alternative ways to actually get to where we need to be. And some of that is like the dissolution of a nation. I don't think that is a good idea. I don't think that should be the top of our list in terms of amendments. I mentioned of ones that are better and could perfect our democracy or move it more towards perfect, right? Nothing's gonna be perfect, but move us towards that more perfect that we are seeking to get there. So yeah, I think our experience with secession has not been a good one. And I think that there is more actually, if we look at these things that bind the American people than actually divide us. So I don't even think it would be prudent.
Okay. Getting back to the problem with corporations, the corporate hijacking of the First Amendment doesn't only include First Amendment free speech, but also the right not to speak. And the corporate hijacking of the Fourth Amendment search and seizure rights and the Fifth Amendment takings intended solely for human beings, all of which profoundly harm people, communities, and the planet. Do you believe these corporate rights should be abolished?
So, you know, I think certainly there's a reason why you have some corporate rights, right? You don't want the government, for example, taking control over like a corporate entity, right? You don't want the government to arbitrarily sort of, you know, tread on things that actually have created some progress. Corporations comes in all different flavors and shapes, right? It's not just your sort of mega ones like Walmart and things like that. You have smaller corporations too. And so I think the idea of completely eradicating sort of corporate legal rights would be a step too far. But I do think that we shouldn't think about them in these sort of constitutional civil rights and liberties in the way that they're trying to use now. Like, I don't think corporations should have involvement in our democracy. I don't think corporations should have involvement in the governance of our country. I don't think corporations should be able to sort of raise these sort of civil and sort of legal or civil and political rights in the way that they do currently. I think that that is just a distortion of our current constitution and the current law. So there needs to be some protection for this sort of business organization somehow, right? We don't want to have completely arbitrary, like if we think about what that might lead to, you know, our past president had threatened corporations in many ways. And I just don't think that's what we want governments doing, is to sort of, you know, that could go down a very, very bad path. But I do think that we need to reconsider what rights corporations actually need and deserve, and all of that should be in service of the country and not only for corporate profits and things like that.
And you know, this reminds me of something that Justice William O. Douglas said. Well, if corporations could be people, so could trees. You know, he said that in terms of environmental legislation standing. So wouldn't that have been nice?
Yeah, trees would, if trees had standing, I think we'd be in a much better place right now.
Exactly, exactly. Well, we have one more question slash comment, and that is right to vote and have your vote counted. The Supreme Court ruled you don't have to the right to have your vote counted, even if you did vote in Bush v. Gore. So I guess that's mostly just a comment, but if you want to comment on that comment, fine.
Yeah, so Bush v. Gore was a complex case. It was a wrongly decided case. I think I don't want to be flip about it and just say kind of what they did there, but I think it was a total perversion of the 14th Amendment and a number of other provisions. We're starting to see this sort of resurgence of this idea of this independent state legislative theory where state legislators completely subvert their own state constitutions and their own constitutional structures because the Constitution mentions state legislators specifically. And that was an off-the-wall theory from Bush v. Gore that is now getting some salience, frighteningly, with some of the conservatives on this current court, many of whom were involved in the Bush v. Gore litigation. So I think there's a lot going on in Bush v. Gore. I guess I'm not sure how to answer the question, except to say that what amendments could do is to, and I mentioned a few that would strengthen our democracy. And I think that's the kind of decision you would not get, hopefully, if you had some people sincerely interpreting the Constitution, if we were to take measures to amend our Constitution in a way to strengthen our democracy. So that is to include this right to vote. That is, right now, we recently had in 2018, we had the Rucho versus Common Cause decision where the Supreme Court said they won't get involved in claims of partisan gerrymandering. We've recently had decisions that are totally trying to undermine the Voting Rights Act. So I think we have a lot on our plate right now. And, Bush v. Gore, I'll say it's somewhat sui generis, hopefully, right? Like it had its own time and place, and it's going to be cabined off to there. We'll see. But I think there's so many pressing issues right now we're seeing with the court taking stabs at the democracy, eviscerating the Voting Rights Act, and allowing states to sort of subvert democracy in ways that are just so pressing and raise the need for amending the Constitution in that regard.
Well, we don't have any more questions from the audience, but if you have any other comments you want to talk about, feel free. Otherwise, I just thought about the interplay between Congress passing a law or an amendment to the Constitution. I mean, there is an area that perhaps overlaps. For example, there could be a constitutional amendment that says that the Supreme Court should have 15 members and term limits, or there could be a congressional, an act of Congress that would do that. Do you see other areas where it could go either way?
Yeah, so for the expand, I am personally a proponent of expanding the court. And I mean, I'm a proponent for a number of reasons, but I will say for a very practical reason, the Supreme Court it hears less cases than it has heard in a century. It's really hearing about like 60 or 70 cases a year. And there are so many more cases that are going on that need to have resolution at the highest level. And so I don't think that it's actually doing enough. And so by expanding the court, by adding more justices, I think you get more bandwidth to take on a lot more. I think you also get like a different perspective, right? Our country has changed. I believe we've had 108 white men, I believe, in the Supreme Court, and only 2 Black men and 5 women. Are we at 5 now? So we're in this place where the Supreme Court has never reflected the diversity that this country is. It has not reflected in a number of ways, right? It's often like a handful of schools that are just kind of producing them all, and then they're all coming from a specific class. So I think there's like experiential diversity that's missing, and with lifetime tenure, the chances of sort of like updating the sort of making the court look like America and being more reflective of America, that becomes really, really problematic. Like, it's been such a brouhaha that our current president says he wants to put an African-American woman on the Supreme Court. Like that should be problematic for some reason. I don't understand it. But we can expand the court by statute. And so I would not want to do that by Supreme Court. One, I don't think it's wise because it takes more to increase to pass a constitutional amendment, and where you can do it by simple legislation. But just generally, I don't think we should do things that you can do under the current constitutional structure, right? Because I think when we amend the Constitution, we should be thinking what the Constitution does not permit, but it needs, and that's really, and we should not be sort of just doing things that we can do under the current regime. But there's a lot of things about the Supreme Court that I would change. I would increase the size of the court by statute. I would get rid of lifetime tenure by amendment, and I would possibly do some other things, but I'll keep them in those two buckets.
Great. Well, one more question did come in. Can Congress pass a statute regulating corporations that would eliminate corporate rights?
So I think that's complicated. I think if we were to eliminate corporate rights, I don't think this particular court's going to go for that. Let's just say that. I don't think they're going to allow like a lot of any corporate sort of rights to be scaled back or eliminated. I think fundamentally, there might be, even if we were to not have the perversion of the Constitution in the way that we have, again, I spoke of like some other things that we think of as corporate rights that are actually pretty reasonable, right? We just don't want the government to completely take over, arbitrarily take over a corporation, right? That seems just like a step too far. And so I don't think that the Constitution would permit that under the reading of most justices just in the past or future. But Congress can do a number of things statutorily to limit corporate abuses. It's just a question of whether they will. And for me, frankly, I think that there are a lot of people in our Congress, and this is one of the reasons why I was talking about infusing new blood into the Supreme Court. I also think we need to infuse new blood in our Congress, because I do think that capture is a real thing, where we have certain interests, as we did in the earlier period, the progressive period, where like interests just have dominated and taken over the agenda. And that's not great. That's not great for the American people. And so it just exacerbates all the problems that we see today.
Okay. I think we could end this particular topic with a comment from Margaret Coster. California's Constitution is a good example of why legislating by a constitutional amendment is not a good idea.
Yeah. And I'll just speak to that very quickly. California has an extremely long constitution. If I've lived in California for a little bit, I went to law school in California, and it is like, there's propositions that occur all the time. Those make it into the Constitution, or like it is extremely long. It's unwieldy, and it's like statutory like. And what we've decided as American people is to have a sort of skeleton framework, right? We do outline how our government's supposed to work. We outline the basic rules for democracy, and we outline the fundamental rights that people need to flourish in this democracy. And so I think generally, while there are other constitutions around the world that have gotten much longer and detailed and things, I think that our sort of framework idea works. It just matters what's in that framework. And for me, I think that the reason why we've started this book and why we want to have this conversation is because what's in the framework now does not reflect what we are as American people and what we need as an American people. We need to have a more robust democracy. We need to have a government that works, and we need to have more security for our rights. And so that's why we need to be thinking about the amendments that we need to add to the Constitution, so that we actually have a national charter that's worthy of us as Americans, and that is more just, fairer, and inclusive.
Well, thank you very much, Professor Codrington. And if any of the attendees want to buy your book, what would be the easiest and best way for them to get it?
It's available in a number of places. I recommend your local bookshops if they're around there. I think that's how I do it. So support your local bookshops, but get it however you can. I think it will be a hopefully fun, fascinating, and informative read.
Well, this certainly was a fun, fascinating, and informative discussion. So I thank not only you, Professor, but all of the participants who made such interesting observations and questions. So it being 7:01, I guess we'll all say goodbye, and thank you all for attending.
Thank you for having me again, and thanks everyone for attending.